Okay, this is 15. Here we go. I got to go back a little bit to get that question.
No, I have not.
You were trained to do CPR in the academy. You didn't say one thing to them
No.
about any kind of threat that Mr. John posed to you at all.
Not at that moment.
All right. And you also indicated.
Another thing she could have got on at this point is, per policy, when we're involved in a shooting, we are told and trained not to discuss it, because when you're in a shooting, because it's a life-threatening incident and you're in fight or flight, you tend to lose aspects of what happened. You're still in a minor state of shock, and sometimes your statements are inaccurate, and you say things that you think happened and you fill in the blanks because of the seriousness of the event. So we're taught and trained not to give statements after critical incidents. She could have thrown that in there. I mean, there's a lot of things that she could have been prepped or that she should be thinking on her own. But again, I can tell she's not an experienced witness. She hasn't been chewed up by a DA, which is probably a bad thing. See, I've been chewed up so many times over the course of my career that I've learned how to do it. So if I ever get in this situation where it really counts, I'm going to have some invaluable knowledge. But when you get somebody like her that doesn't have that knowledge, your attorney needs to help you. They either need to prepare you, or they need to stop you, or they need to give you a clue or a hint, or they need to walk up and whisper something in your ear, or they need to object. There's plenty of ways that the attorney can mess up this DA's flow, and he does it not once. Well, he did do it once, I think.
That you've never done CPR before.
No, I have not.
But you were trained to do CPR in the academy, were you not?
We were trained. I've never done it on an actual person.
All right, so at least then to the extent that you weren't suggesting that you didn't know how to properly perform CPR.
See how he kind of implied she's lying? You weren't suggesting that you didn't know how to do it. That's not a question, Your Honor. She already said that she received training and that she's never done it on a person. Can you have the DA form his question in the form of a question, or state his question as a question and not as testimony? He just told my client that she implied something or insinuated that she's implying, and that's inappropriate. Where the hell is her attorney?
They taught us briefly in the academy.
You knew how to perform CPR properly, right?
I never done it on a person. I couldn't say
Ms. Guyger, were you trained to do...
He interrupted her? Again, with no objection. Nothing's changed. The judge isn't stopping him. The attorney isn't stopping him. He's bullying her, and he is winning on every round of this fight. And it pisses me off, because he's a punk, and he shouldn't be winning.
Do CPR properly?
Yes, we were.
Okay, were you at those classes?
Yes, I was.
Were you paying attention during those classes?
Yes, I was.
Did you properly perform CPR on Mr. John?
No, I did not.
And you could have, right?
I tried to do little CPR.
Why would you try and do a little CPR on a man who's dying who needs your full attention?
Because I had to keep getting up to see where I was at.
That was more important than giving life-saving...
He interrupted her. He totally misrepresented her answer. He just made a statement that what she answered was an opinion, that it was more important. She didn't say it was more important. He said it was more important. And he's not letting her answer. I mean, this DA is just eating her up. And I am so pissed at her attorney and the judge for not stepping in and saying, dude, you need to freaking relax. You need to ask your question and let her and stop testifying.
Help to this man.
I had no idea where I was at.
You were able to tell the 911 call taker very, very soon on that you were in apartment 1478. After that moment, why couldn't you have given him full, undivided, and proper attention?
I was still on the phone with...
You can put...
See, he's trying to get her to answer a reason. And the real reason is, I just used deadly force. I was in shock. I was so confused on where I was at. I was still processing information. I could barely even figure out where I was at and what was going on. I was still trying to understand how I was on the 4th floor and not on the 3rd floor. I was confused. It wasn't like you sitting here today being able to read a checklist off to me and telling me what I should have done. It was a rapidly evolving, chaotic situation where my life was in danger and I just had to kill somebody, and I just realized I was in the wrong apartment and killed the wrong person. I was feeling like shit. I'm sorry that I didn't do everything perfect. I mean, she could have defended herself, and that's why I kind of feel sorry for her, because I'm like, damn, he's beating you up so bad. It's kind of like kicking somebody when they're down. Once you win a fight and they're already down, stop kicking them already.
Put the phone on speakerphone, ma'am.
I had so much stuff racing through my head.
Oh, obviously, you were also able, at least on 2 occasions, to, you must have stopped completely giving him CPR when you sent a message to Martin Rivera saying, I need you, hurry, right?
I did text him that.
Okay, and so you must have at that point stopped CPR entirely.
Yes.
I already told you I didn't do CPR because I'd never done it on a person and I was nervous and panicked. I did a sternum rub. I tried to do a few compressions. And a matter of fact, what she should have said and what the attorney should have prepped her to say is the reason I didn't do CPR is he was breathing. I didn't think he was dead. I already told you he was partly conscious. I testified he was conscious. Remember when I said earlier he should have qualified why she knew he was conscious? That would be a good point right now. You don't do CPR on a person that's breathing. CPR is for somebody that's not breathing and their heart stops. You do, I mean, there's just 1,000 ways she could have got out of this, and it just looks like she's lying, or he's implying she's lying, or he's confusing her, or she's not real competent, or she's really stupid, or she's acting really stupid, or you just don't want that kind of image going to the jury.
Yes, I did.
And then, not even a minute later, you must have stopped CPR entirely again to send a second message to Martin Rivera.
I was already out in the hallway.
Oh, so you had already left him.
That's whenever they told me to leave, the officers.
So that's, no, ma'am, I'm talking about at 10:03 p.m. Mr. Lee, Officer Lee, and Officer Blair didn't arrive until almost...
See how he can change the question? He gets her to answer the questions, and he's not specific. And now when he doesn't get the answer he likes, when she goes, I was already outside, now he's changing the question. No. Let me tell you, at 10:05, now he gets specific. See, I mean, the attorney should have objected to that. Your Honor, he didn't ask her at 10:05 what she did. He just said, you text a second time. My client testified that they had already gotten there. Now he's changing the question, making it seem like she's being uncooperative or not answering his questions. Would you please tell him to ask the question clearly and let my client answer? Why isn't this attorney defending his client? I don't get it.
10:05.
Yes, I do remember that. Like, whenever they showed me, I sent those text messages.
At 10:03 p.m. and at 10:02 p.m., you sent messages, text messages to Martin Rivera.
Yes, I did.
See, the DA just testified that really wasn't a question. And she made it a question by answering it. The DA made a statement. You sent text messages at 10:03 and 10:05. It's not a question. Did you send them? Do you remember sending them? That would be a question. The DA just made a statement about when she sent texts, and she answered, yes, I did. She's not even listening for a question now. Her attorney should walk up to her ear and go, make sure he asks a question before you answer, and if you don't understand, have him repeat it and make him clarify. I mean, gosh, good grief.
Messages that would have required you to have put the phone in a place where you can see it, and you used your fingers to write out the words, I need you, hurry, ... right?
I don't remember how many hands I used.
But you texted Mr. Rivera using your hands.
Yes, I did.
And as...
See, now she's answering before he even finished the question. So now he gets to ask multiple questions without stop talking, because she's answering and confirming his statement. He's giving testimony, and she's confirming it before he even asked a question. And her attorney isn't even going over there saying, hey, don't answer unless there's a question. Don't help him send you to prison. Good freaking grief.
You were doing that, you were unable to give Mr. Jean your full attention, the attention that he deserved.
Yes, I did.
And then you made the choice to do that a second time. Isn't that true?
Yes, sir.
See, she just said, yes, sir. I made the choice. I didn't make a choice. You make it sound like I had all this time to sit around and decide what I was going to do. You keep forgetting that this was a crazy incident where somebody died, and you're kind of making light that the person died, trying to make it about me sitting around like I'm drinking coffee and eating his ice cream. I mean, it just irritates me the way this DA is allowed to get away with.
All right, so at both of those times, you put your needs and your wants over his.
I still cared about it.
That wasn't really a question, and he's got her answering and justifying his statements, and the attorney isn't objecting.
Did you put your needs and your wants over him when you decided to do that?
No, I did not. No. Let him prove it. I did not do that. That was not a conscious effort. I did not think about putting my needs. I was in a panic. It was confused. There was a million things going on. I was still trying to figure out where I was at. I was trying to get the cops and medical there to help him because I know that he shouldn't have been shot. And I was sorry, and I was worried, and I was confused. And it was a crazy incident that happened in seconds, and you're making it sound like I was sitting around on a Saturday night drinking a beer planning all this. That's not the way it went down, counselor. Oh!
No, sir.
All right. And then you went out into the hall. You left him alone.
When I heard the officers coming, I stepped outside.
So you decided to do something other than continue to give Mr. Jean life-saving measures.
I wanted somebody there fast to get him
You're
help.
not going to answer my questions, are you?
Yes.
So now he's accusing her not answering. Your Honor, he's interrupting her, and now he's testifying that she's not answering his questions. I just heard her answer his questions. What is he talking about? This DA is out of control, and nobody's holding him in check.
Sir, I am.
When you went out into the hall, you did that because that was what you chose to do, even though you knew you should be giving that man life-saving treatment.
Yes, sir.
He got her to agree to that. I can't believe it. Even though she testified to that, she just gave false testimony. She did not think about any of that when she went out in that hallway. She never once thought about, you know what? This guy's dying and I just shot him and I'm in the wrong apartment and shit's probably about to hit the fan. But you know what? I'm going to go ahead and decide not to give him CPR just for GP. That's what I'll do. Does anybody believe in their right mind that that's what she did? Yet he just testified that's what she did and she just agreed. Are you freaking kidding me?
You didn't know that he was going to die. I mean, you knew he was in really bad shape, right?
Yes.
You didn't know at that moment in time that you'd actually shot him and severed his ventricle from his heart. You didn't know that, right?
No, I did not.
In those moments, you know as a trained officer just how critical it is to make sure that you give.
Are you testifying? Are you telling my client what she knows? Or are you asking a question? Who the hell's running this monkey courtroom?
Life-saving treatment as fast and as proper as possible so you can maximize their ability to survive.
Is there a question there? He just gave a statement. This DA is doing more testimony than the person on the witness stand. I can't believe it.
Know that.
Yes, sir.
And yet, despite knowing that repeatedly, you made choices and decisions that suited you more than him.
No, sir.
You also indicated that you had done CPR, but yet there's no blood anywhere on your uniform or on your shoes.
There is not.
Okay. The next thing I want to talk about is you and Mr. Shook kind of recreated from your recollection what you were able to see inside apartment 1478, especially with respect to the movement of Mr. Jean. Is that right?
Yes, sir.
Okay, and I'm going to see if I can recreate this. So you said this was about 30 feet away, right?
Yes, sir.
Okay, and you said that you saw Mr. Jean doing some sort of a pacing thing, right?
Yes, he was moving back and forth.
Okay, how many seconds did this last?
Very few.
2, 3, 4, 5?
See? She says very few. Earlier she testified 2 seconds. Now we're getting into time instead of saying it was in milliseconds. It happened so quick, I have no idea how quick. In my mind, it was racing, and I lost track of time. I don't know. I don't know is perfectly acceptable answer. For some reason, when inexperienced people get on the stand, they feel like if they say I don't know, they think it's going to be held against them. I don't know is a much better answer than making something up that can be used against you and then later proved that what you testified to isn't true because you made it up. Because in fact, you didn't know, but you didn't want to say you don't know.
I couldn't give you an exact number.
That's good.
Okay, well, I want something a little bit as best you can give me.
Maybe
See? I can't give you an exact number, and what does he do? I want you to give me something as best as you can. Again, this is where she gets her point across. I'm sorry, I told you. It happened so quick. I mean, it seemed like a split second. My door opened, I saw somebody movement, I drew my gun, he was coming at me, and I fired. I mean, all of that happened so quick. It was so rapidly evolving. There was so much going on. I can't give you an answer. I'm sorry. I wasn't looking at my watch, and if I give you an answer, it would be a guess. Do you want me to guess? And then they would object, because they don't want you guessing. So you ask them. If they want to force an answer, you say, do you want me to guess? Because I don't know, and I've already told you I don't know. Do you want me to guess? No, I don't want you to guess. I want you to tell me an answer, because I've played this game, and some attorneys will wear it out until the other attorney objects. I mean, they'll go back and forth. I don't want you to guess. I want an answer. You were there. How am I supposed to know? And I was like, I don't know. I was there and I don't know. Why don't you know? Weren't you paying attention? Can't you estimate 2 or 3 seconds? I can estimate 2 or 3 seconds, but I don't know everything was happening so fast. I don't know how long it was. Just stick with it. Nobody's going to hold that against you.
2 or 3 seconds.
2 or 3 seconds.
Now she gave him a time, even though, and see, again, her attorney could have objected. Your Honor, asked and answered. Before she said 2 or 3 seconds, he could have said, Your Honor, she already answered she didn't know. Can you instruct the DA to move on? Because that's all they can do. But no, the attorney didn't say nothing. He goes, I want you to guess. The attorney didn't object. What does she do? Now she guessed 2 or 3 seconds. Now she's locked in at 2 or 3 seconds. Guess what's going to happen? She's either got to show it was longer or she's got to show it was shorter, and she's got to justify it. And then it's going to look like, so when you said 2 or 3 seconds, that wasn't right, was it? And since she's been getting beat up this whole time, you think she's going to say, well, actually, I said I don't remember, and you kept badgering me, so I just guessed at 2 or 3 seconds. She's not going to have the forethought to say that.
Seconds, you're standing there at the door. The door is fully open, right?
Yes, sir.
The hallway that you're standing in with the door fully open, there's bright lights out in that hallway, isn't there?
It's lidded.
It's bright as heck, isn't that right?
Yes, sir.
Okay.
Again, he just changed her testimony. There's lights everywhere. She goes, it's lit. She said lidded. She's just nervous. It's well lit in that hallway. Actually, it's bright as hell, isn't it? And she agrees. Yes, sir. Now he's got you to where you can see everything in the hallway and it's bright. Now, from the flip side, if it is really bright in that hallway, I would have brought that up earlier, saying she went from a very well-lit area to a dark area by the doorway, which is why she didn't see the numbers and why she didn't see the mat, because her eyes were not adjusted to the nighttime vision. I would have used that in my favor if that's true. I don't know how well lit it was.
And those lights were coming into Mr. John's apartment, which allowed you to see him doing this, right?
I could see from it was just lit, so you could still see his movements a little bit from, I guess.
I'm asking you.
See, what she should have said is, I could not see him. I saw movement and shadows. It appeared to be a body going back and forth. I wasn't sure because I couldn't see. As I have testified, it was dark and I couldn't make it out. Stick to your story. Stick to the truth. Don't let them to start get you ad-libbing and adding shit. Bad testimony on her part.
Very simple question. From where you were standing in the doorway, you've indicated to Mr. Shook that you were able to see him standing at the back doing this, and you've indicated that was for about 2 or 3 seconds. Is that your testimony or not?
Yes, it is.
Okay.
So now, not only did he trick her into saying 2 or 3 seconds, now he's got her saying it twice that it's her testimony. So now he's got her locked down doubly, and when he proves it's a long time, and when he proves it was either shorter or longer, guess what? She looks like she's lying. She can't be trusted. She's changing her testimony. Oh, man, this is like courtroom failure 101.
To see the furthest, into the furthest reaches of his apartment from the door, and you were able to actually see him doing a very distinct motion.
He was moving.
Okay. And so then you say...
That was a good answer. All I saw, she said he was moving. I think a better answer would have been, all I know is I saw a shadow and movement. That's all I know. Don't make them get you more specific. What was the shadow? How tall was the shadow? How wide was the shadow? How many times did the shadow move? Did the shadow move left or right? Was it moving more left or more right? Don't get caught up in all that crap. It was dark. I saw movement. I was in fear of my life. Somebody was in my apartment. I thought I was going to die. I thought deadly force authorized. I drew my gun and made a split-second decision, which happened to be wrong because I was in my wrong apartment. Had I been in my apartment, we wouldn't be here today.
You saw him walking.
Yes.
Or coming towards you.
Yes.
Okay, and then you said that at about here, from here to where you were at the door, that's when you decided to shoot twice.
Yes, sir.
Okay, that's called a double tap, right?
Yes, sir.
Is that what you were intending?
Yes, sir.
That's your training, isn't it?
It's what we're trying to do.
It's training double.
See how he's jamming her with questions? See, the other flip side to him allowing to do this is he's getting in twice as much of his information to the jury as the other attorney did in twice as much time. Because the other attorney was talking slow, he was letting her answer. So from a jury perspective, the jury is hearing a whole lot more of her agreeing with him than they did of her testifying with her own attorney. Man, she needs to slow this down. Her attorney needs to be objecting. Her attorney needs to be whispering in her ear. I mean, oh, this is so sad to see her get beat up like this.
Double tap maximizes the lethality of your shooting, doesn't it?
Yes, sir.
I mean, it's better.
So he just got to agree that double tapped it maximizes the lethality of your shooting. So he's walking her down a path that you wanted to kill him because you double tapped. No, we're trained to double tap because very rarely does a single shot stop a suspect. And not only does a single shot not stop a suspect, but most officers miss. As a matter of fact, I fired twice and only hit him once. So our hit ratio as a police officer is somewhere around 16%, which is very low. And that's why officers involved in shooting shoot multiple times very quickly, because 1 or 2 rounds rarely stops the threat. And I was in fear of my life. I was trained to double tap. And when he moved at me, I fired twice. And when he fell, I stopped firing because I knew the threat had stopped. That would have been a better answer. I hope you're seeing a theme to what good answers are and what bad answers are. Rick, you're just picking on her and you think you know her. Shut up, you big crybabies. Listen.
Better than one shot to the heart.
Oh, shit. I'm at 22 minutes. All right. We're going to go back and we'll make another one. I think this will be 15.